It's just gone 10, so we're now live, and welcome to everybody that's joining us for OGR Studenton's webinar on business issues that are impacted by COVID. This is the second webinar that we've undertaken on these issues. I think in particular, often lawyers host seminars on particular distinct points. But we recognise that particularly in this situation where we're in, COVID has created what I would describe as a perfect storm. And whereas lawyers operate in our distinct fields, business and family units and individuals don't. And that's why we've got the benefit today of three specialists in completely separate areas. I've got my colleague, Stephen Silverman, who I work with closely generally in our dispute resolution department. We've got Robert Rosenberg, who is a transactional commercial lawyer with the emphasis on commercial. And we're really delighted and very grateful to welcome Chris Milson, who's an eminent barrister from Cloisters Chambers, specialising in employment law. So hopefully the aim is to have not a dry seminar on a distinct legal point, but to have a lively discussion on the issues that are affecting everybody in the country at the moment, and how potentially we can assist in some way. I think where we'll start is with my colleague Stephen Silverman, who, as I say, is a specialist in dispute resolution. He does personal injury law as well as commercial litigation. Stephen always takes a very holistic approach. He's excellent on his interpersonal relations. And I think without further ado, Stephen, I'll be interested to hear what you say, how the debt recovery and enforcement position is occurring in these current times. Stephen.
Thanks for that, Ian. Well, it's hard to believe, but it's been 11 weeks now since Boris made that announcement on the 23rd of March that we were going into lockdown officially. And since then, businesses have certainly been having a very difficult time. And I've been dealing with a number of people who have come to me because they're owed money, and they want to know how they can actually recover that money. And things are changing now as to the best ways to try to enforce a debt or to recover outstanding monies. And also, I try to stress how important it is to avoid further debt, or to avoid incurring debt in the first place. So I'm just going to give a few tips, I think, today, really, as to how to avoid debt. And also we will be talking about certain things that we can take into account and the best ways of trying to enforce a judgment, if we've got that, to try to recover money as well. So I think, Ian, one thing which is very important is that a person does know who they're dealing with when they actually start a commercial relationship. I get quite a lot of people coming to me who don't really know who they dealt with. They're not sure whether they're dealing with an individual or whether it's a partnership or a company. And we need to drill down straight away to find out who the relationship was with, who the contract was with, because it's going to affect the various enforcement methods that we can take. I always say get as much information as you can about the person you're dealing with, because we can use that information further down the line to try to recover a debt. For instance, you want to get full names of the people that you're dealing with. You want to get bank details if you can. That can be useful. You certainly want to get email addresses, because even now it's difficult to rely on the post, and a lot of people aren't receiving their post. You want to be able to email people, and you really want to have as much information as you can. Certainly a solicitor is going to be asking you for copies of any outstanding invoices, copies of any emails relating to any disputes, because we need to know if the debt is disputed, it's going to make a difference as to how we act as to whether or not you think there's a genuine dispute in relation to this debt or not. So what I would actually say is be careful when you're dealing with people. Make sure you've got as much information, particularly at the moment. Be careful with giving credit limits. Quite a few people come to me who have had a customer that may have put in 3 or 4 orders that they've paid for, relatively small orders, and then they put in a big order, and it can be quite enticing to go along with that big order and to give extended credit, and then quite often you can end up by being stung by that. So if someone does come to you and wants to have a larger order, then perhaps you can ask for some form of security for it, or deal with it by installments, or even take up credit references to make sure that you're covered. So what happens then if you've really got yourself into a situation where you are owed some money? What's the best ways of proceeding? Well, I always say that, act quickly. For a start, people do forget the good work that you did. If you've done a job and they're pleased with it, then that's the best time to get paid. If you're looking to recover a debt 4 or 5 months down the line, that's always going to be a bit harder. But the first thing that we can do, of course, is a 7-day letter. And quite often we will find that if we send a solicitor's letter to somebody and we explain that, this debt's outstanding and we ask for it to be paid, then it will actually start some communication. Even if the debt's not paid in full, it will start some communication, because people come to me and they're very frustrated that they haven't actually heard from the debtor at all. They may say they've been sending emails, they've been trying to phone, they haven't, they're just being fobbed off. And in these times, it's not surprising that companies who are having a difficult time are going to deal with the people who shout the loudest and try to put off some other people. So solicitor's letter will actually normally prompt some response. I don't know if you find that, Ian, but I certainly do, that first letter is very important. It's important to get the facts correct, but it's important to try to engage with the debtor as well.
Yeah, very much so. I think sort of, as you say, getting the basics is so often, sounds obvious, but is just one of the basics for what you need with these things. And if you get it wrong from the outset, you're on the back foot. Similarly, if you get it right, you're on the front foot and you're progressing forward immediately. Don't you agree?
I do agree. And also, if you do get the response and someone phones up and says, look, we're having a really tough time at the moment, is there something we could do about it? I do say to clients, you're going to have to be practical at the moment, because even if you go ahead and get a judgment against somebody, it's only a piece of paper. You're going to have to enforce it. And as we'll see, the types of enforcement methods that we may have taken in the past aren't all available to us in the same way as they may have been. And so if we can build a dialogue with someone who owes you money, and you can work out a way of perhaps that they're going to pay you over a period of time or with some security, that may be the best way forward at the moment.
I mean, how has the new regime, in post-corona, how has the law changed in terms of how you and I would normally work, and the advice and the action we can take? How's that changed now?
Well, it's changed quite dramatically, and it's changing very quickly as well. For instance, there's various enforcement tools open to us to try to enforce a judgment. One of the ways, which was always very successful, was to instruct a bailiff, or you could register your county court judgment with a high court and instruct a high court enforcement officer to actually go round to someone's residential premises and to say, look, you owe £5,000, I want to know what assets you've got, and I can take those away or whatever. But now, because of social distancing, there's actually been some new rules, got quite a long heading actually. They're called the Taking Control of Goods and Certification of Enforcement Agents Amendment Coronavirus Regulations of 2020. And what they basically say is that now bailiffs and high court sheriffs, enforcement officers, can't just go round to people's properties and seize a vehicle which was always a very good way of enforcing a debt if there was an expensive vehicle on the drive which wasn't leased and it was actually owned by the debtor. They also can't now go into people's homes or ask people to give up assets as security for the debt. And so we haven't really got that option open to us when it comes to those types of enforcement.
And what about on the sort of, I know one always often with a reasonably sized debt, a statutory demand as a precursor to winding up?
Well, statutory demand was always a very useful tool that we could use. You could actually serve a statutory demand on a company, and you would be able to say that if you don't dispute the debt and you're not able to pay for it within 21 days, then you'd be able to use that as evidence that the company was insolvent, and you could then present your winding up petition. It wasn't always the best way forward, because once you present your winding up petition, all the other creditors are going to jump on the bandwagon as well. But just getting a statutory demand itself was something which a company would take note of, and quite often wouldn't want to have a winding up petition issued, because once the winding up petition is issued, then it becomes advertised and it can cause lots of problems. Even if that particular creditor then gets paid, the winding up petition is still there for the other creditors. It can cause issues with your banks and all sorts of things. But actually, only just recently, on the 20th of May, the government, which had already been giving strong signals that it wants to help companies who are suffering issues, has now put before Parliament the Corporate Insolvency and Governance Bill. And that's going to go through Parliament quite quickly. And some of the legislation is retrospective, particularly in relation to statutory demands. And what you're going to find now is that you're not going to be able to proceed with the statutory demand and indeed issue a winding up petition if it's really down to the fact that it's a debt which has arisen as a result of coronavirus. And also, it's going to be on the creditors. He's going to have the onus of establishing that COVID-19 isn't something which has caused this particular debt to be able to pay.
Yeah. So, it's interesting, because when we were at the outset, before we formally began this webinar, when we were all speaking, and Chris was saying how these regulations have been brought in so quickly and so speedily without any sort of parliamentary scrutiny. And, the government and everybody's saying they're asking the public to behave responsibly. And I know on the 7th of May, the government issued guidance on responsible contractual behaviour in the performance and enforcement of contracts. And in fact, in that document, what they're saying is, whilst we know in a contract you may have your force majeure rights and you can plead frustration and, all these abilities for contracting parties to either get out of a contract or seek damages for failure to perform, the government is issuing guidance to say, we know you've got those rights, but we're asking you that these are really unusual circumstances, and we just want you to not necessarily resort to exercise your full rights and behave what they describe as responsibly. It's not enforceable, but
So this the bill is actually going that far, and there's some quite worrying things in it. I mean, there's actually clauses in that bill which actually prevents you, if you're actually dealing with a company and the company is having difficulties because, for instance, one of its major customers has gone insolvent or something. That doesn't actually mean that you can just now say to the company, right, well, I'm terminating my contract because I'm worried I'm not going to get paid. And so there's provisions in the bill to prevent you from being able to do that. And one of the things which is also very concerning for creditors is that the companies are going to be able to have a moratorium which will prevent you being able to take any action against the company, whether it's a debt relating to COVID-19 or not. They're going to be able to apply to the court and have, I think it's 20 business days within which to try to get themselves together in order that they can try and trade through this. And, and there's some very far-reaching provisions within that bill. For instance, one of the things which is always protected, if you like, to a certain extent, people dealing with companies, is that directors aren't able to trade whilst they know that they're insolvent. And in fact, that can be an offence, and serious action can be taken against the director, so that if the company's wound up, and insolvency practitioner can actually investigate what actually the directors knew at the time. And now that's going to be changed. There's going to be have some protection. The directors, in other words, I think what the government is saying, they want to give directors an opportunity to continue trading without having to worry that perhaps they're insolvent and shouldn't be doing so. But so it's going to be for directors to behave in an honest way in doing that.
Okay. So I think the message really is that from an enforcement perspective, not all bets are off, but quite a lot of bets are off at the moment, because obviously on an economic level, money's just not flowing around, and it's just people are going to have to be more patient.
Well, they are, but there's also, and I would say that when I started off with about getting all the information that you can from the person you're dealing with, why that's so important is that there's certain methods of enforcement which are still out there. Third-party debt orders, for instance. So if you're owed money and you know that your customer has got a bank account, you've got details of that bank account, you can actually obtain an order to serve on the bank, and if there's money in the account, then you would be able to get access to the money in the account to the extent of your debt. And that actually is something which is quite a successful way of enforcing a debt. It used to be the old Garda-She proceedings. Do you remember that, Ian? That we used to call them? That's the party debt order.
So some of the enforcement methods are there, but the more draconian, like winding up those things, the government's putting a timeout on at the moment.
I think that's a good way of summing it up.
Stephen, very enlightening. It may be, as questions come in, that we'll be discussing this further. At this point in time, we're going to move over to Robert Rosenberg, who is a commercial transactional lawyer in real estate. I've worked with Robert for many years, and I would say in my dealings with Robert, what he brings to the table in particular is his ability to strip things down for the client, to give them just what they want, not just reams and reams of paper that he deems everybody does, but he focuses on what type of client he's got and gives them what they need. Robert, you're going to give us some tips on landlord and tenant in this environment.
Thank you, Ian. I know this is the part of the seminar that everybody wants to see, the real estate part. This is the sort of the Joe Wicks bit segment. So I'm really excited to tell you, an update on what's happening in real estate. So, well, the first and really most important message I want to tell everybody, because I don't know whether you're a tenant or a landlord. I speak to both tenants and landlords, and I can tell you, you're both in pain. 100%, you're both hurting. And because sometimes you only see things from your point of view, which I guess, I understand. If you're a landlord, well, if you're a tenant, you've lost sales, you're furloughing staff, you don't have people coming to your restaurant or people come to your shop. Even when you're allowed to reopen in the middle of this month, you've no idea who's going to come in. If you're a barber, you don't know how close you can get to people. It's going to be really confusing, and you're hurting. Now, so obviously you don't want to pay your rent. Now, if you're a landlord, you're also hurting. Now, I know a lot of us always think of landlords as being, the big guys in the ivory towers. But there are a lot of small landlords out there, and they've got mortgages to pay. So suddenly they've not got the rent that they get from the tenants and not able to pay it to their mortgage, and suddenly they have to find money from other places, and they're hurting too. And there are a lot of small landlords with big tenants who can do things like go into CVAs and all that kind of stuff. So everyone's in pain. Now, why am I saying this? Because if you understand where the other side is, then you're more likely to talk sensibly to them and come up with a good, sensible deal. Okay? So what's a sensible deal? So the first most important thing is talk. Everyone's got to talk, because we're in a moment of time when one day, hopefully, we're going to look back on this and we're going to talk, we're going to tell our kids and grandkids about the time when people stopped and went home and didn't do anything for about 3 months, the coronavirus time, the first time schools were shut, and that time will pass, and you're going to be remembered by your tenant or your landlord as to what you did. So talk. What can you do when you talk? What sort of things can you talk about? So the first thing to note, to give you the law, because I am a lawyer, is that the government has basically stopped landlords chasing for rent. It's just basically impossible. I mean, and Stephen and Ian will say as much. But whilst they're not allowed to chase for it now, it is a debt that's not gone away. So, and it's important. So if you've got a mortgage holiday, you still will have to pay that at some stage. It's not gone away. It's not a rent-free, just like it's not a mortgage-free. It will one day come back and bite you in the bum. So it's important to remember that the tools that landlords don't currently have they won't be stopped from using them forever. So bear that in mind. Now, if you're a tenant, you should try and negotiate a rent-free with the landlord. How do you do that? Well, you get on the phone and you say, can I have a rent-free? What can you offer in return? Well, you can say, I'll stay there. I'll stay in your place maybe 6 months longer. So I won't pay rent now. I'll get a rent-free now, but I'll stay with you guys for another 6 months. Now that gives the landlord a bit more comfort. It gives him, it stops rent in the short term, but gives him a bit of comfort about his asset later on, in 2023, 2024. You could also try and fix a rent review now. Lots of things that you're able to sort of try, and now that we're sort of past the stage of huge panic, you can sort of say, right, well, we're now in a stage where we sort of know what's going to happen. Yeah, there could be a second wave, or all of those things that might happen. Now, I want to talk to you about something new that's happening in landlord and tenant. Now, I've done this for 20 years and nothing new ever happens, right? There's iPhones that come out in tech, and there's new marketing strategies, but nothing new ever happens in landlord and tenant. But we get
that's why normally you guys are so interesting, isn't it?
Is why we're introduced first at dinner parties as the commercial property lawyers. There's us guys, we're solid. There's no messing about with us. What we say, we know it's true because it's happened for 10, 20, 30, 40 years, right? It's never going to change. But what's been really cool, so I've been talking to tenant and landlord lawyers about the new coronavirus clause. What's a coronavirus clause?
Oh.
Right. So unbelievably, nobody knew that we're going to have coronavirus. So when people got out their leases and said, right, can I get out of paying rent? Most tenants realised they couldn't, because it didn't have a clause in there that said, when coronavirus hits, this is what happens. It's amazing when you consider that a lot of leases run to about 60 or 70 pages, all of which is mostly rubbish. And we couldn't find the coronavirus clause because it wasn't there. So we've invented one. Now, what is it? Well, it's now... Well, it's not fully decided yet, because you've got tenant lawyers on one side and landlord lawyers on the other side. But tenant lawyers want to say that the next time coronavirus strikes, or any virus strikes, we all have to go home and, live with our families for the next 3 months. We don't want any more rent to pay. We don't want to have this argument over do we pay rent, do we not? We just want to say we're not paying rent anymore. Not only that, everybody knows that when they get back to the shops in the middle of this month, are hardly going to be running to the stores and buying everything in there. So, they also want a bit more of like a stepped rent after that. And that's the tenant point of view. Now, the landlord's point of view is, well, maybe we're happy to give you that as long as we can insure against it and you guys pay the insurance. One thing we all know is that it'd be pretty difficult to find an insurance company at the moment who will step in and pay the rent for if a shop has to shut in the case of an epidemic. I'm not sure you'll find any insurance company willing to be up for that today. But you never know. In 5 years' time, it might happen. So landlords and tenants are now, struggling when they're renewing leases. They're saying, what about this coronavirus clause? Tenants want more. Landlords want to be able to insure against it. So that is the new clause where people are really coming together and trying to work out what's the norm. The last time we did it was probably 20 years ago after 9/11, where we had an insured risk clause and then we had to have an uninsured risk clause. So it's been 20 years. So landlord and tenant lawyers are super excited about being able to negotiate a brand new clause. And that's it as an update. That's sort of where we are. But things are changing all the time, and people are trying to do new deals and get over this thing, talking like the other guys have been saying, because frankly, without cooperation, we all rely on each other to be able to get through and create business, create wealth, and go on nice holidays or whatever it is that we do.
I mean, I think it's interesting what you're saying. The advice in particular I'd pick up on is that obviously, whilst there's no enforcement rights, or very few, in landlord and tenant at the moment, the debt has not gone away unless you negotiate it away. So continue to engage. And I think that's often what we hear from clients. The worst, I think, and I'm sure you'll agree, you can do in the landlord and tenant relationship is to adopt radio silence.
Yeah, well, radio silence makes everybody nervous, doesn't it? And if a landlord can't get hold of his tenant, that makes him nervous and thinks, well, has he gone away? Am I going to have to re-let it?
Yeah, I think the other thing is everybody's going through difficult times at the moment. That's a given. I mean, it's almost glib. Okay, but what a landlord is stuck with at the moment, this legislation is only temporary legislation. It's not going to last. So if you've got a relationship, somebody in the future, the landlord's going to say, well, when it got tough, I knew where I was. Whereas if you've adopted radio silence through this, once this temporary legislation lifts, and if the market will move at some point, history has taught us, think that the market goes up, the market goes down. When it moves, it will be payback time, won't it? If you don't have that relationship.
Absolutely, the relationship's very, very important. And tenants don't fully understand what the view of the landlord. The landlord's generally got more experience and might know that their area is going to be okay, and they could just rent out something, having kicked out the tenant. But there is obviously. It's very glib also to say there's a hell of a lot of uncertainty. So, nobody really should be stamping their foot. They shouldn't really get to that stage of thumping the table. Yeah. Because we don't know. And it's just through good dialogue that you'll get to a result that's going to help over the years and years.
Stephen, I think whilst Robert's talking about sort of landlord and tenant, on the enforcement side of that, is there any sort of new groundbreaking law there? I know for commercial property lawyers think the Landlord and Tenant Act 1925 is new, but what's really new in case law?
Well, we've got the bill at the moment, which is, as I said, just being placed before Parliament. But actually, what the courts seem to be doing now is that they can see where the law is going to be, even though it hasn't been passed. And there was a case actually only this week on Tuesday, which was in the High Court Chancery Division, where a landlord who was prevented under the Coronavirus Act from forfeiting a lease decided to bring a winding up petition against a retailer for the money that was outstanding. And the retailer tried to restrain that from happening and actually brought an injunction to prevent the winding up petition from taking place. And what the judge said, well, it's quite clear where the law is going. There's a bill before Parliament. I think that that's going to be passed, and that in this particular situation, you wouldn't be able to bring a winding up petition. And so he actually granted the injunction, prevented the winding up petition from being granted on the basis that the law was going to change, not as the law is at the current time. So right. I think that where you're going, Robert, is quite right. You can see where the court's going.
You see, I think that's that encapsulates everything. The court basically said, landlord, what are you doing being such a whatever?
Yeah, precisely.
You're live, remember.
I'm live on MTV. But it is there you are. I think you've also got to think, how would I want to be treated here? And I think the judges there said, you know what, guys, this isn't right. This isn't right. Everyone's struggling here. The government said what it said about winding up. Behave the way you'd want to be treated. And I think that's it's very good news that the court said that. And I think that's a message to people, and they should take that on and think, well, that's how the judges are going to behave as well. So it's up to us to find our own way of compromising between landlord and tenant.
Yeah, Robert, one final question, Robert, for you. You've given some good advice, and generally the takeaway is speak with each other. Now, let's take that as a given, and you're negotiating landlord and tenant about what you're going to do. We are lawyers at the end of the day. Can the landlord and tenant just reach a deal, send each other a few emails, and that will sort it out? Where's the point where you would say to an existing client, you know what, that you can do on your own, you don't need me, but this, come to me before you do anything? What would you say to that?
Okay, so the first thing I'd say is don't do this over WhatsApp. Right? I mean, start it over WhatsApp if that's what you want, fine. But when you finally got an agreement, get something down, definitely on an email, but definitely on an email. If you can, you want to do a letter to each other. So if you agree monthly rents going forward, you would put that in a letter saying you've agreed that from now on we can do monthly rents. And if you could, get a landlord to print it out, sign it, scan it back to you. That's going to work 99 times out of 100, really. Where, and that's a big, that's something you can put in a drawer rather than a WhatsApp that might get deleted one day or something. So to formalize it doesn't need to be, you don't necessarily need to go to lawyers, but for something like monthly rents. But if you do something like add on extra time at the end of your lease, if I were your landlord, if a landlord solicitor would definitely advise that you should go to lawyers for that. Again, it shouldn't be a lot of money. It should be a deed of variation or a side letter. But you should go to lawyers if you were doing a deal that's a little bit more substantive than just saying from now on we're going to pay you monthly. So I hope that answers the question.
Yeah. Okay. Excellent. Thank you for that. Well, I think now we're going to move over to our final guest this morning. Unfortunately, in the situation that's been created, by far the biggest issue, both on an economic and on a personal level, is the employment relationship. It doesn't need to be saying the majority of people across the country are concerned about their businesses and their livelihood. We are genuinely very fortunate and very grateful to have Chris Milsom joining us this morning from Cloisters Chambers. Chris is a specialist in employment law. He's been voted as one of the top 50 advocates in the country on this in his field, and is described as operating at the cutting edge of employment law. No time other than now has tested employment lawyers to get on top of legislation that's been brought through so speedily. So without further ado, Chris, over to you to raise some of these issues.
Well, after that introduction, Ian, I'm bound to disappoint. So it's probably better I say nothing at all. Good morning to whoever's out there. It's a bit surreal at the moment. We can only see 4 TV screens and speakers, so it may be that we're speaking in the wind. But hopefully, there's someone out there on pirate radio.
That's lawyers for you. We're often speaking in the wind,
literally talking to ourselves.
Yeah.
I don't think anyone could have anticipated quite where we're at. Employment lawyers have a tendency, like a somewhat disaffected school staff room, to bemoan every change that comes our way, think that it's the next big sort of sky falling in, and we've had a few of them over the recent years. The imposition of tribunal fees was a significant impact. Brexit, the ongoing effect of that is going to be interesting. But this challenge of going from lockdown to work is the biggest that's faced industrial relations, certainly in the post-war period. Very easy to lock the country down. How you ease that lockdown is going to vex in every conceivable area. I have just put onto the Zoom webinar chat link a link to a fairly detailed guide that we at Cloisters have prepared. It runs to the grand total of 162 pages. I think there's a lot of useful stuff in there, but just to give you a flavour of the sorts of things to consider. How do you get people back to work if they haven't been working at all? How do you ensure a safe system of work that enables social distancing? If you have to vary terms and conditions, how do you do it remotely if some still work? And if you are conducting redundancy consultation, how does that work? What do you do with the vulnerable people, whether disabled or not, or who are shielding for others, that can't return to work? What do you do with those who say that there are issues with their route to work, which mean that there's a serious and imminent threat in their eyes if they do have to attend the workplace? And on this day, which is the 20th anniversary of the race directive, the EU mechanism, although in truth we've had race relations protection for some decades before that. What do you do with a particularly vexed issue at the moment, which is that we know there is a racial disparity in the contraction and death of individuals from COVID-19, but we don't know the cause of that yet. Are BME colleagues entitled to say, look, I'm Bangladeshi, I'm twice as likely to die of this as my white colleagues. I don't know why, but I'm not going to return to work. What does an employer do in those circumstances? All of that is broad, vexing. There's no case law on it. The furlough scheme was easy, frankly, compared to what we've got down the tracks. And I'm happy to take questions on some of those. What I want to spend a little bit of time talking about, since I can't begin to answer those questions in the time we've got, all I say is that the handout, I hope, is of use. It's detailed and comprehensive and prepared by a whole host of people who know their onions, is to talk about what is perhaps one of the more important features on a practical level, which is, it's all very well having these, wonderful Baroque rights of employment, wonderful Baroque rights of employment. How do you begin about enforcing them? Because at the moment, it's not just every business that's in partial or full lockdown, it's the tribunal system itself. We know that from the tribunal president, we're going to be dealing in little screens of boxes until, at the very least, the end of the year. Because this week, the president of the Employment Tribunal has provided what's called a roadmap towards facilitating full hearings. That roadmap envisages that tribunals will not be hearing whistleblowing and discrimination cases until around November, December of this year. And if it does so, it will be done remotely. One thing to think about there, in order to enable open justice, the web link via Skype, or what the tribunal system is using at the moment, CVP, is a kind of the remote video platform. That web link will be made available to the public. And so, whilst in many an employment dispute, the prospect of somebody trundling along with their sandwiches and cagoule to Watford Employment Tribunal was pretty slim, now there is a prospect of somebody sitting at home with their popcorn, potentially dialing into multiple hearings at the same time. And when you're dealing with cases where the reputation of a business or an individual is at stake, it's really worth thinking about the potential privacy applications you might want to make in relation to those hearings, and do so at an early moment. I think, given all the questions there are as to facilitating that return to work, really the buzzwords, sort of practical tips are: think carefully, think creatively, and be strategic. It's all very well, this happens very often, a government of any colour, employer, use your common sense. We're contracting out to you the social good of employment protection, over to you. That is a huge weight of responsibility. And I think the starting point is to think, where economically is my business? To what extent can social distancing be accommodated? What's the makeup of my workforce in terms of age, health conditions, race, and caring responsibilities? And how best do I muddle through? Mistakes will be made along the way. Communication, transparency, and prior thinking are the only way through all of that. And as I say, I hope that the guide that I've just sent through gives you some pause for thought as to sorts of issues that might come up. I don't propose to say anything else at this stage, just because if I start entering the bear trap of any of them, we'll be here until 10:45 tomorrow, the next day, the day after that. But if there are any questions about specific things that you have down the pipeline, then do just say. One other thing just to mention, I don't want to say too much about furlough. It's matchsticks and eyeball territory. But if any employer wants to make use of furlough before the 1st of July, which is the kind of cut-off point, you need to do it 3 weeks beforehand. And so any furlough application that has not been prior furlough needs to be on the 10th of June. So next Wednesday. Then we're going to have the interesting fun and games, an important step, because it was quite a binary system. You're either on furlough or you're not, or flexible furlough from the 1st of July. But all of that comes with the caveat of think about your business, think about your workforce, and think how you can navigate these difficult waters.
I just, funny enough, but just one quite practical question. I don't know,
sure. Since
lockdown, have you had any remote tribunal hearings? Really?
I've had remote appeals,
right.
which are a bit like this, frankly.
Right.
It feels like you're in a sort of legal resistance movement. Everyone's in their bunkers, and we're all sort of little faces on screens trying to argue points of law. But I mean, I've had remote appeals, and there are some remote applications along the way. But the other thing to say is that I'm not sure how many people listening have got litigation down the track. It's completely incoherent depending on region what's going on. Cases in the Bristol region, which would include Exeter, Bristol, of course, and in fact some of the Welsh tribunals, have really got it going very well. That from their perspective, the regional offices are open. If anyone is desperately inclined, they can sit there with their sandwiches and watch there. And so there has been some effective applications taking place in Bristol. In London Central, nothing is being listed at all. In Watford, for example, you'd be lucky if you get a response within the next 6 months to any piece of correspondence. So, depending on where your case is being heard, you get complete regional variation as to how well advanced the system is. But it's all creaking towards getting answers to pretty important stuff, frankly.
Thank you. Well, I mean, you identifying all the various areas that are going to come into play in the next few months, as you say. It's easy to lock down. Coming out is going to be where the tension will occur in certainly in the employment relationship.
Yep.
And so no doubt you and us are all going to be very busy. Chris, I want to in particular thank you for finding time to join us today. We really appreciate it. I hope that everybody or anyone who is listening to us has found it useful. I think the headlines, the takeaway from all the different speakers is that we really need to be engaging with each other in whatever legal relationship you're in, be it a commercial, landlord and tenant, employee, employer. The government is stressing acting reasonably, and I think we don't need the government to tell us. I think most of us, the majority of us, are sensible enough to know that it's only going to be working together that we're going to get through this. Obviously, legal issues are going to arise, but even when one needs and obtains legal advice, I think where we see, and you've heard today from Chris, Stephen, and Robert, it's this sensible commercial advice that is so important, as opposed to just giving a formulaic legal analysis. So I think that's the formal part of the proceedings over. We'll stay online and just sort of have a chat and wind up. And if there are any queries, please don't hesitate to send something in. Similarly, you can go to our website and various social media links, ogr.denton.com. You can go to Chris Milsom's website or link on Cloisters Chambers, where they have got a large amount of information there on employment issues. And overall, our message is be well and stay safe. So thank you.